I'm Jen Hunt from SUNY Buffalo State. I'm really honored to be kicking off the talks today. And my talk today is on studying the effects of race, ethnicity, and culture on jury behavior. Target effects, subject effects, and interactions. So to begin with, why should we examine the role of race in jury research? I'm hoping that this is a moot question for the people assembled in this room, but in case it's not, both statistics and individual cases suggest that race may play a meaningful role in legal outcomes. So just to give a couple of examples. First, there are large racial disparities in incarceration rates, especially for men. So if you look at the rate of incarceration per 100,000, we can see that the ratio of incarceration is 5.8 to 1 for African American to white men, and it's 2.5 to 1 for Latinos to white men. We can also look at some high-profile cases. So for example, the recent case of Troy Davis, who was executed last year. Mr. Davis received the death penalty after being convicted of killing an off-duty police officer who was white. And there are many people who believe that race played a significant role in that outcome. Now, how do we explain these racial disparities? Obviously, there are a number of factors that may contribute. One factor we can consider are differences in the actual commission of certain crimes across racial groups. We can also consider the relationship between race and other factors that we know are associated with crimes such as socioeconomic status. It's also important to consider discrimination by criminal justice and legal system professionals, such as police, prosecutors, and judges, as well as institutional discrimination in the form of things like sentencing guidelines. But finally, with respect to why we're all here today, it's important for us to consider the influence of race on judgments made by juries as well as jury behaviors. So how much research has been done on this? Well, to provide a very crude measure of this, if you put juries as an index term into PsycNet, you'll see that there are about 1,200 peer-reviewed journal articles. If you restrict those to those that mention race anywhere in the abstract, it goes down to 70, which is under 6%. Now, I'm very hesitant to provide a comparison group because I don't want to suggest that any one topic is more or less important, but if we look at some other topics of interest, we can see that there's been relatively more research on other areas of juries. So it would be great to see more research being done to assess the impact of race in jury work. So based on our existing research, what do we know about the role of race in juries? Well, first, we know that racial minorities are less likely to be chosen for juries in the first place. There are a number of factors that contribute to this, but one factor of particular importance is that attorneys often will use their peremptory challenges to exclude racial minorities from the pool of potential jurors, despite the fact that that's prohibited by the Batson decision. And the lack of racially diverse juries can lead to a number of other problems. For example, the lack of confidence in the jury system. And moving on, we also know that race impacts the verdicts and sentences that are reached by juries. If we look at experimental work using mock jurors, we can see a pattern in which mock jurors are more likely to convict defendants who are members of other races than members of their own race. We see this pattern in the 2005 meta-analysis by Mitchell and colleagues. Dennis Devine is working on updating this meta-analysis right now, and his preliminary results show similar patterns for this. We also, if we move to deliberating juries, can see that juries that have higher proportions of white jurors have an increased likelihood, sometimes a substantially increased likelihood, of convicting minority defendants. And finally, if we look at archival research on the death penalty, we can see some evidence that Black defendants are more likely to receive the death penalty, but particularly strong evidence of Black defendants receiving the death penalty when their victims are white. And finally, our current research shows very strongly that racial effects in juries are complex and they're moderated by several factors. To name only a few, racial bias in jury decisions tend to be stronger, as I mentioned earlier, when victims are white, and also when crimes are stereotypically associated with the defendant's race. So for example, homicide for Black defendants and embezzlement for white defendants. Racial bias is also stronger when race is not a salient issue in a trial and when jurors are not provided clear judicial instructions. So that's what we do know about the role of race in juries. What don't we know? Well, I'd like to argue that the answer is a lot, and that we have some really tremendous research, but I think it represents the proverbial tip of the iceberg. And so what I'd like to spend the rest of my time talking about are my thoughts on a research agenda for moving forward. And I'd like to argue that developing a comprehensive understanding of the effects of race on juries requires research that addresses the issue from multiple perspectives. And so to borrow a framework from research in the psychology of gender, I'd like to argue that we should be considering target effects, subject effects, and interactions. And I'll discuss each of those in turn. When we're talking about target effects, we're considering how judgments about specific individuals, for example, defendants, are influenced by their race. And this is what most of our existing research is on. There are a number of studies that do simple manipulations in terms of using pictures or using different names that will imply that a defendant is a member of a different racial group. And there's some good work that's out there, but we definitely need to take the next steps. First, we need research that goes beyond the basic black-white dichotomy. We need research that examines bias against other racial and other ethnic groups. There are a growing number, but still a relatively small number, of studies that look at bias against Hispanic or Latino defendants. Evelyn Mader recently published a study that shows that Muslim defendants are more likely to be convicted when they are wearing burqas or hijab. And we definitely need more research in this vein. We also need research that looks at racial bias involving parties other than criminal defendants. So for example, attorneys, judges, expert witnesses. And we need research that extends beyond the context of criminal trials. We need to look at the effects of race on civil trials and outcomes, for example, damage awards. And right now there's very little research that looks at race in the civil context. And I might suggest to you that we might need to do a little soul searching and consider whether we as researchers are being influenced by stereotypes ourselves if we're only looking at race within a criminal context. Beyond expanding the scope of our research, we also need to increase our integration with the broader body of research in social and cognitive psychology on stereotyping and prejudice. To put it frankly, sometimes our work in this area isn't very theoretical, and I think there's real benefits to an increased theoretical component to this work. So for example, research that has incorporated aversive racism theory in jury research has identified several important and not always intuitive moderators of bias. Also, there are a number of very interesting new papers that consider the role of implicit racism, such as automatic or unintentional racism, on legal context. But most of these papers are written by critical race theorists and other legal scholars and have not really translated into the empirical work that is needed. We also need more research that really examines the psychological processes that may underlie racial biases in jury. So for example, there's a recent paper by Heather Kleider that showed that lack of cognitive resources can increase the likelihood that jurors who are prejudiced will act on those prejudices in their verdicts. So that's the target perspective. What about subject effects? Well, when we're considering subject effects, we're talking about how jurors' own group memberships, that is their own race and ethnicity, influence their judgments and their behaviors while serving on jurors. And there's really very little research that has addressed this issue, and particularly research that has moved beyond race to consider ethnicity and culture. When we're talking about culture, we're talking about the shared knowledge, values, and practices of a group of people. And there's a thriving field of cultural psychology that has shown that culture impacts the way that people see and evaluate the world and the way that they interact in it. But this research has had almost no intersection with jury research. So some things that I would like to see would include research that looks at the way that jurors' race, ethnic, or cultural background impacts their judgments. To throw out a couple of questions, does distrust of the justice system among minorities lead to a higher occurrence of jury nullification? There's some intriguing analyses on this topic, including by people in this room, that kind of support both positions. I think we need more work on the topic. Also, there's a large literature that's looking at the way that culture impacts judgments of morality. And I think it's worth asking, do cultural differences in views of morality affect judgments of particular crimes, of defendants, of certain victims? It would be really nice to see some integration between this work and our work. We also need more research that looks at the effects of race and ethnicity on jury deliberation and jury dynamics. So for example, Sam Summers published a very provocative study that showed that racially diverse juries deliberate longer than all-white juries. They discuss more evidence, and they discuss that evidence more accurately. We need to consider to pursue this line of work. And we need more research to look at the role of culture in jurors' interactions. So for example, I have some in-progress research that shows that jurors from Asian and East Indian backgrounds, and more generally, jurors who have an interdependent self-construal, that is, jurors who see themselves in relation to others and value group harmony, express less comfort with the direct communication that's often required in jury deliberation. They're less comfortable sharing their perspectives on a case, and particularly less comfortable disagreeing with other jurors to argue for their chosen verdict. Finally, we need to continue examining interactions. As we've seen, the impact of race, ethnicity, and culture on juries is very complex, and our research needs to continue to reflect that complexity. I've talked about target and subject effects as distinct factors, and to some extent they are, but we definitely need to be continuing to look at interactions between them, how the background of jurors is affected by the background of defendants and other legal actors. We also need to continue to pursue research on moderators of racial bias, and this can include case variables, individual differences among jurors, situational variables, but I would like to argue that it would be really beneficial for us to particularly study what we can call system variables. And so to take a page from the eyewitness literature, there's been a distinction made between estimator variables, factors that are outside of the system control that can only be post-dicted in terms of their influence, and system variables, which are under control of the criminal justice system and can be improved. And I think that we should consider that approach while studying the impact of race on jury behavior, and look at things that the legal system can control that will reduce jury bias and or promote positive interracial and intercultural dynamics in jury deliberation. So in conclusion, I do realize that this is a challenging research agenda that I have set out. There's logistical challenges in terms of recruiting diverse samples, research involving jury deliberation. There's also potentially a need for additional expertise on issues such as cultural psychology that may require more inter as well as intra-disciplinary collaborations. But I'd like to argue that believe it's necessary for us to overcome these challenges in order to develop a fuller understanding of the effects of race, ethnicity, and culture on juries. And I think that ultimately it comes down to this. Jury systems in this and in other countries are growing more and more diverse. And right now, we can really only speak to a small slice of the way that that diversity affects jurors. If our work is going to remain relevant, we need jury research that employs multiple perspectives and examines multiple groups, behaviors, and outcomes so that we can capture the variety of ways in which race, ethnicity, and culture may impact juries. Thank you very much.
I think although I'm going to talk about some different things, specifically more focusing on the civil justice system, that Jen and I are going to touch on some very similar themes. And so just a little bit of review of my background. Like I said in my introduction, I'm currently a trial consultant working in Indianapolis, and I've been doing that for 7 years. I work at a large Midwestern law firm, and that's different than being at a standalone trial consulting firm from what I gather. And I consult on cases within our firm as well as outside of our firm and cases across the country. The bulk of my work is civil cases, particularly consulting on the defense side, the civil defense. And so those are cases that involve product liability, insurance, patent claims and intellectual property, commercial litigation, contract disputes, labor and employment, and class action. And I've also consulted on the plaintiff side on a few civil cases, and on the criminal side, it's mainly been white-collar criminal defense. So that's just to give you an idea of what my background is, and this talk is based a lot on my experience rather than data, and so of course my experience colors my opinions. So, in addition to my employment history, I have also been fortunate to serve on the editorial board of Law and Human Behavior for the past 7 years, and I've also been an ad hoc reviewer for NSF grant proposals. And so what I've been able to do is to have the opportunity to compare the submitted articles and proposals with my experiences of the cases that I see in the real world. And I think that's why Margaret invited me here to bring that perspective to the talk. So what I have here is a graphical representation of research in the field of juror and jury decision making. And I created this with a program that some of you may be aware of. It's called Wordle online, and you capture a whole bunch of text and you put it in, and then it creates a graphic making larger the things that are more common. So I took the reference section of Dennis Devine's Psychology, Public Policy, and Law, tried to try and get some data in my talk here some way. So I took that reference section and I did some coding on it to code for things like the type of case, whether it was criminal or civil, and the general research questions that were addressed. So was it eyewitness testimony? Was it jury size, damages? And then this is what came up. So I think that's kind of interesting. But then when you look at this, the question is, well, is there anything missing from this? And if there is something missing, what is it? And when I look at this and I look at our field, what I see that's missing is issues concerning advocacy and the adversarial nature of litigation. And it's important for us to include aspects of advocacy in jury research because, number one, we want the research to describe and apply to real-world jury decision-making, and we want attorneys and courts to consider our research useful and informative. So, an advocacy is a special aspect of the situation that jurors find themselves in. From the moment the jurors step into court, the attorneys on each side are trying to persuade the jurors in ways that are favorable to their clients. And I'm not sure that the research that we conduct always captures that adversarial nature or the advocacy component. So this is where I start to have some similarities with Jen's talk, though I use different terms, that you can categorize the jury research into areas of juror or jury performance or juror and jury persuasion. And the way that I think about the research on jury performance are studies that have examined the effect of procedural issues. So this includes things like jury size, decision rule, juror note-taking and question asking, jury instructions, including the timing of those instructions and the language used in those instructions, also issues of bifurcation and joinder, things like that. And these studies typically measure aspects of performance such as amount of recall, accuracy of recall, and comprehension in addition to verdicts. In comparison to that, you have what I refer to as studies that focus on persuasion, and the studies that have been conducted to date, for the most part, I would argue, look at issues like defendant race or gender, appearance, inadmissible evidence, hearsay evidence, pretrial publicity, damage requests, and some models of juror decision-making. And what these studies look at on the outcome side are verdicts, verdict shifts, or movement in verdict preferences over the course of a trial. Now, the performance studies looking at decision rule and jury size and things like that are factors that the courts control. And so those studies are very informative when the courts are trying to make decisions about, do we allow juries of 6, 8, 12? Will we allow jurors to take notes? What's that going to do to the process? The hopes is that it increases their comprehension, their recall, their accuracy. On the persuasion side, the research on defendant race and gender and pretrial publicity, of course, very important. But what's missing, once again, from this picture are things that attorneys have control over and how they bring advocacy to the cases that they try. Okay. So what litigators basically want to know is, how do I win this case for my client? I mean, that's what it is, and a lot of academics, I think, don't want to get into the advocacy component and understanding that, yeah, it isn't all fair all the time. People are pushing, they're going to do whatever they can to win their case. But that's the real world of litigation. And so I think when I look at research that I'm asked to review, one of the questions that I look at as a marker among several about what makes jury decision-making useful or interesting is this a question that relates to how litigators prepare and present cases? And does the data inform them to what they would actually do in a case and how to try their case? So the things that attorneys have some control over include their case presentation, which is often just referred to as the story that they tell at trial, the way that they question witnesses, both on direct and cross-examination, and what goes to that is also preparing witnesses for depositions as well as testifying at trial. Demonstrative exhibits, which are exhibits used to illustrate or explain oral testimony or recreate an occurrence or an event that's part of the case, and this is introduced through witness testimony. And then jury selection, or of course more accurately deselection. The attorneys have control over their use of peremptory challenges during jury selection. So these are the things that the attorneys want to know about. This is what I have control over. Can you give me some information from your research that helps me inform my decisions and my behavior on these things? So here are questions that I think are of interest to litigators. And what I have here, of course, you all recognize, this is a graphical representation of the story model of juror decision-making, first proposed by Reed Hasty and Nancy Pennington in the mid-1980s. And this model has had, I would say, the biggest impact on attorneys and the field of jury decision-making in general. It, of course, addresses the various sources of information available to jurors. You've got the trial evidence and the jury instructions, which is the information presented in court, as well as prior world knowledge and prior knowledge about the law, which is the information information that the jurors bring to court with them, and then we look at how those jurors process those various pieces of information and integrate it to reach the verdict. So this is one of the best known psychological concepts among litigators as well as lawyers in general. But what do lawyers know about the story model? I think this is all they've taken away from it, is that you need to tell a story. So I think in addition to the fact that this is mainly what lawyers have taken away from it, that if you question psychologists, that a lot of them would say, this is what they know about the story model also, that you need to tell a story. But that is just the tip. We don't know, we can't really tell attorneys how do you tell a good story, because we've all heard attorneys tell stories at trial, and some of them are good and some of them are not so good. And so I think it would be helpful if the research could start to dig deeper and look at the story model in more detail. I think that as a group, we have not explored what makes a story plausible, coherent, or complete. And in addition, we haven't conducted much research on that examines the influence of the prior knowledge that jurors bring to court and how that impacts their decision making. So more specifically, we've got these questions, which are, will the jurors perceive my story as plausible in order to help me understand whether, as an attorney, I'm telling a good story? And what's the influence of their prior experience and their prior knowledge on their beliefs or their perception about whether the story that's being told is plausible? The story model tells us that I need to be able to explain the evidence. I need to incorporate the evidence into my story so that the jurors won't think that I'm hiding the ball. But oftentimes, I'm faced with bad evidence. As an attorney, I'm wondering, what's the best way to manage that? Should I really ignore it? Should I try to minimize it in some aspect? Or would it work better to reframe that bad evidence in some way? And every story doesn't just stand on its own. You might think of the story of a case as the 2 or 3 sentence snippet that an attorney could say, this case is about, and they would give you that short description of it. But that story is built on themes, and attorneys will be able to identify for you the themes that make up their story. But stories differ in complexity, and so I think one of the questions out there is there an optimal number of themes that jurors can handle? For example, 7 plus or minus 2. Is there some way, if you can't go beyond that, even in the most complex case, because jurors can't process or recall more than that? I think that's a question to look at. In addition to the characteristics that are currently included in the story model, I think that some things that would be useful to incorporate are the persuasiveness of the story, whether it's memorable, and whether it can withstand attack. And these are characteristics that are tied to the nature of the attorney's task as well as the juror's task. So the jurors, what we sometimes forget because we focus on the story model, which is what's going on in jurors' heads, they're actually presented with 2 or more stories at trial coming from the attorneys. Each side has the story they're telling. What do jurors do with that? Just because the attorneys are telling a story doesn't mean that the jurors take it at face value and just spit it back out. If they're integrating that into some sort of single story, what does that look like? How does that story compare to the story that each attorney told? In addition to the story model, I think an aspect of jury research that has not been looked at too much, but that is key in the minds of attorneys, is juror emotion. And specifically, they're looking at anger versus sympathy. And we're always asked, is anger or sympathy more influential on my final verdict? Do I need to worry about making jurors angry, either at me as an attorney or at my client? It can work both ways, and attorneys track that throughout the case. And are there certain things, are there certain themes or aspects of the defendant or the plaintiff that trigger emotions, in particular emotions? Are there emotions besides anger and sympathy which should be taken into account? And I can tell you that in our practice, once again, just based on our experience, not a lot of data, particularly because there isn't much data in the area, that we sort of operate on the belief that you push jurors to, a good story for the plaintiff or the prosecution is to say that an injustice has been done. So there's an imbalance here, and the jurors have the power to correct that, to bring back some balance. And so on the defense side, you're looking to say, wait a minute, no, there is no injustice, or it would be an injustice if you found the defendant guilty or liable. So there's an underlying aspect there of injustice, and how does that tie into the emotions of the case to affect juror decision-making? And I think that attorneys are very interested in that, and that would really help them in how they do their job. And this applies, of course, to both civil and criminal cases. Another area of research is demonstrative evidence and demonstrative exhibits. And this is part of every case, but it's something that very little research has been done on, although, Jen, you remember I was talking with some people around the table about demonstrative exhibits and how it impacts juror decision-making. So there's a wide array of the types of demonstrative exhibits. You've got graphs, charts, timelines. In addition, you have photos and x-rays, and something that we refer to as interactive exhibits with the graphics programs available today, which most attorneys at the law firms have access to. You're able not just to present a serial PowerPoint where you go slide to slide, but you can make your graphics so that it's almost like a web page, right? And so you can bring something out and you can set it back. So you've got in the background a timeline or a basis of information that jurors can always attend to, and then they understand where these individual components fit into the big picture. And so those are becoming more popular also, and so I think that's an interesting aspect of demonstrative exhibits to take into consideration with some research. Now, the general belief about visual evidence and demonstrative exhibits is that pictures are better remembered than words, and there's some research that's been conducted years ago on the picture superiority effect, which basically finds this, that pictures are better remembered than words. But in court, of course, not all demonstrative evidence is equally visual. So you have things like text that's up on the screen through PowerPoints, which even today, attorneys are so tied to words, they think if I just put the words on the screen, the jurors will understand what I'm talking about, but jurors don't. But you can have a range of things from static diagrams, which are almost cartoonish, to more sophisticated animations and photos. And so we have all of those things that we haven't yet explored to really appreciate the differences in demonstrative exhibits, which I think are a key component to juror decision making. And we consider the area on demonstrative exhibits as an intersection of psychology, the law, and graphics, because the law provides the content. When you, the psychology, you're looking at what do jurors take away from it, how do they remember it, is it tied to some emotion or some favorability for one side or the other based on visuals that you presented. And then you've got the graphics. So I think they're great opportunities for cross-disciplinary research in this area. And the things that we want to know are different types of demonstrative exhibits. Do they affect memory, comprehension, emotion, and the perceptions of the case? Then finally, we've got jury selection. And the cases that make it to trial are likely to be balanced in terms of their strength of evidence. If they weren't balanced, they would settle, or they'd get settled through or dismissed based on summary judgment. So we have cases going to trial that are more likely balanced than not. And what we see in our trials that we consult on, as well as in our jury research that we do before trial, is that you very often end up with two camps of jurors which see the case very differently. And it's not surprising given that the cases are equally balanced, but then that highlights for the attorneys the importance of jury selection? Is there something about what jurors are bringing to the table, what they're bringing to the courtroom, that locks them into one side early, and then from that point on influences how they perceive the case? And so there's more research to be done on jury selection so that the attorneys, can make informed decisions about their peremptory challenges. Now, some of the research that we've done, of course, has compared demographics to attitudes, and we find that demographic characteristics are not very predictive of verdict leanings, and attitudes are more predictive. But an area that I think we've overlooked is this component of previous experience, and this is where I think research using college students is not as good as research using community samples, because in the actual cases, jurors are saying things like, well, when I run my business, I talk to my employees this way. I expect this of my employees. When I sign contracts, when my son was stopped by the police, okay? College students cannot bring those experiences to them. And so although we haven't seen differences between community samples and student samples in a lot of research, I think that it's still likely that there are differences there that are impacting verdict decisions in the real world. Another reason this is important is that although, yes, attitudes are tied to final verdicts, lawyers' opportunity to ask a lot of questions about attitudes, particularly, I would say, in civil cases. In criminal cases, maybe the courts allow more extended voir dire, particularly in death penalty or big cases. You can have voir dire that goes on for a week or more. You can also have voir dire that lasts 15 to 30 minutes, and you have a very limited ability to ask questions. You definitely don't have the ability to ask numerous attitude questions that ask the same sort of thing in a slightly different way. But information about previous experience, which is, have you previously served on a jury? Was it a civil jury or a criminal jury? What was the outcome? Were you the foreperson? Do you volunteer? What's your military experience? These things are on every standard juror questionnaire across the country. And the attorneys have access to that information, if nothing else, and they want to know, does that influence the verdict, and can I do anything with that? Will that help me make better decisions? But of course, sometimes we do have opportunities to ask questions about attitudes, and when we can do that, that's very helpful, and of course, we would like to do that. Now, we have looked in the field at a handful of attitudes, including legal authoritarianism, need for cognition, the civil litigation crisis belief scale, but there's so many attitudes that haven't been examined to date which can impact the cases, and they're more case specific, so beliefs about contracts or experience with contracts, beliefs about science and attitudes towards science, things like privacy and chemicals and insurance companies and executive compensation. And one of the reasons that research in this area would be very useful and I think welcomed by attorneys is that a lot of the, most of the work that consultants are doing are on large bet the company cases. Those are the cases that of course can afford the jury research. But there are a host of other cases, smaller cases like personal injury, hit and run, even medical malpractice cases are not always a large amount of money. And of course, there's all sorts of attitudes that can affect juror decision making in those areas. In addition, another thing that's important, I think, to look at in this research are the ability to ask single questions rather than scales about attitudes, because once again, attorneys often don't have the ability to ask numerous attitude questions. The court will say that's redundant. You can ask one of those questions, but you can't ask all of those questions. And if you have 15 minutes, you don't want to take 10 minutes asking questions about executive compensation. You would like to get at more things than that. So in general, I think that then speaking to the applied issue versus the theoretical issue, the litigators want to know, well, how do I win this case for my client? But the researchers want to know, well, where's the theory behind this? And I always think that it seems pretty simple in my mind when I read the research and look at the studies coming in, that yeah, the attorneys want to know what makes a difference, but then as a researcher, you just go to the next step and you say why and how does that make a difference, and you can study the same thing but inform both the applied area and the theoretical area. Okay. And so I think, given the time limitations, that is it. Thank you very much.
Okay, first I want to thank Margaret for inviting me. I'm not a natural choice for a conference like this. As I said, my background is largely in decision theory, and I came from a business school. I spent 17 years at the University of Texas Business School. And I just want to start by telling you about one of the first talks I went to was from a psychologist at Texas who came across to the business school and gave a talk on his ideas of a framework for decision theory. And I was sitting next to the chairman of my department, and I thought it was a pretty interesting talk. And the chairman said, what'd you think of that talk? And I said, I thought it was pretty interesting. And he said, I didn't. And he said, that's one of those, here's what I think talks. Well, who cares what you think? Right? And that always stuck with me when he said, well, who cares what you think? You may have that feeling by the end of today as well. But for what it's worth, I'm going to give you a few thoughts about what I think about jury research, what I think the goals of jury research are and should be, and where I think we should go. Here are some goals that I imagine jury researchers have or should have. I suppose you can think of others, but this is sort of kind of the big three. Number one, develop theory. This is something that interests all of us. It interests all the psychologists. It's what we're good at, it's what we're trained to do. But at the same time, in this particular field, like many applied fields, like the fields that I know from the business school as well, like the fields of management or consumer behavior, we want to apply the theory that we have to a specific situation. And the specific situation here is, of course, jury decision making. So I think most of us here are really interested in more than just developing theory. I think we want to apply those theoretical insights to juries. We want to say, this is how juries actually do it. In other words, we want to describe decision-making in a very particular environment. Now, that may not be your goal, and that's fine, but I suspect it is the goal of many people who do jury research. And a third goal that may or may not be a typical goal is to evaluate and attempt to reform the jury process. Regarding goal number one broad theme, of course, is how people think and decide. And I think using legal scenarios is a terrific way to gain insight into things like what role do evidence and argument play in belief formation? Can we identify individual differences that predict how people will respond to different evidence and different arguments? Dan Kahan has offered a model that he calls cultural cognition, where he claims that people can be classified into 4 different groups. Once you know what group we're in, that goes a long way towards predicting how you're going to respond to evidence and arguments at trial. What role does emotion play in decision making? If people's emotions are aroused by things like seeing a dead baby, will that influence the way they influence subsequent evidence? Will that influence the way they view the characters in the trial? As for cognitive bias, the civil trial is a great way to understand, to gain insight into things like hindsight bias. After all, that's what a civil trial is often doing. They're engaging in a form of hindsight. They know that there was some bad outcome that occurred, but they're asked to judge what the defendant knew or should have known in foresight. But the jury themselves has the outcome information, and so you have kind of a natural hindsight situation there. A second theme, so in addition to judgment and decision-making generally, I think jury researchers are or should be interested in groups. Scott Tinsdale and Norbert Kerr have taught us a lot about this, and they've showed us that juries can be a wonderful environment for trying to understand group decision-making. Just a few things that I thought about, and I'm no expert in group decision-making, but these are some topics that might be of interest. How is consensus developed? When people get together in groups, do they really share information? or do they simply conform? What are the social pressures like in juries, in groups? What sort of deal-making goes on? What sort of roles are played by the leaders? Now, all of these are things that have been studied by people who study group decision-making, and one way to study these things is to look at juries. But it's a separate question, I think, as to whether juries are engaging in the kinds of behaviors that the group decision-making teaches us. I say this because I think the jury environment, and this is not a very deep thought, is a very unique environment. I think it's an environment unlike any other. And you could say that about almost any decision-making environment, but I really think that the jury decision-making environment has so many features that make it such an unusual place to be, to make decisions, that it's not clear how easily we can import what we know about decision-making into this environment. I won't go through all of those things there. Most of them are probably familiar to you. You know, decision makers are just summoned to appear to make a very important decision in a matter in which they have no expertise whatsoever. And in fact, they're trying to get out of it. They don't want to make this decision, but nevertheless, they have to be there. But I'll just call your attention to, I'm not sure how the pointer works, about the seventh one down. Decision makers suffer through testimonial interruptions. I'm not sure anybody has ever studied this because it's so difficult to study, but the reality is that trials go on for hours and hours and days, and there's so much stuff that happens during a trial, so much irrelevant stuff, so much boring stuff, so many interruptions. The judge will say, okay, jury, now you need to step out. Jury, you need to disregard this. Jury, you need to only use this evidence for this purpose. There's so many unique features. No decisions that we make have those kinds of unique features. And my question is, the thing that occurs to me is, do these things matter when it comes down to what the jury is going to decide? Do they matter with respect to the variables that we psychologists are testing in our laboratories? And they might matter, and they might matter in a big way. They might actually interact with the variables. They might change the outcome variables that we get. I'll give an example later on how they might change things. But probably more importantly and more generally, do they simply mute and make insignificant all of the effects that we find? Something that we find in a 2-second manipulation may be quite irrelevant in the context of a 40-hour trial. And a third goal of jury research for many people, not all, but for many people, is to evaluate how well juries are doing and to consider and test various reforms. And people who have this goal in mind commonly talk about things like that. How do we make the jury decision-making process more accurate? How do we get better verdicts? How do we make things more fair? Policymakers may have other objectives in mind. They may think, how do we make things more efficient? How do we make things more cost-effective? These are not very interesting questions to psychologists typically, but they may be quite interesting and important to the policymakers who you may be trying to persuade. So that's just something to consider. We may want to think about research questions along those lines. So you can probably see already which way I'm headed with this, which goals need more attention, which goals need less. I'm going to commit heresy by saying less theory, less theory. The goals that I think need more attention are more veridicality, focusing more on how juries actually decide if we're interested in what juries are actually doing, and jury reform, that also could use more attention. So regarding goal number 2, and this isn't news to most of you. I know that the lines are drawn and we're on different sides of these matters, but you've all heard the ecological validity concerns, the specific concerns like the artificiality of the lab experiment, the simplicity of the lab experiment, the lack of stakes in the lab experiment. These are familiar points, and these are are shown pretty nicely, I think, by this quote from John Monahan. And he, of course, isn't the only academic who worries about these things. Sherry Diamond, right here, my colleague, has said that she's concerned about who we're putting in our studies, the participants. Again, an obvious concern. But Sherry makes the very interesting point, and she did this in a paper back in 97? You've made it many times. Where we need to make sure that we have a theory of participant before we're so quick to buy into Brian Bornstein. I'll just use you. You may not believe this, but You're the straw man for now, yeah, for my talk. You won't be in Dan's talk. You'll be the main man in Dan's talk. No, but Sherry's worried and concerned, as many of us are, about whether jury characteristics interact with the materials that we have, and the nature of the case that we give people, whether it's deliberation or not deliberation. And her general recommendation is, let's just not use students. There's so many disadvantages to using students, so many things we don't know. You know, going back to Christina made this point as well, that maybe we should use jurors from the community. Rich Weiner feels the same way. In a recent study that he co-authored in Behavioral Sciences and Law, he found that student jurors and community member jurors responded differently in homicide and sexual assault cases, depending on which kind of case was being evaluated. What's at stake? This is a tough one. This is a tough one because almost nothing's ever going to be at stake in our jury experiments and our simulations, but courts are going to be skeptical about participants in social science studies, and they're going to say, you know, how can we trust these results when there were no consequences associated with the decision? You know, this is a very extreme statement from Supreme Court Justice Rehnquist. You know, and if you take it literally, then none of our studies mean anything because there's never any stake, almost never any real stakes in our studies. For what it's worth, reviews of you know, the role that incentives play in decision making generally don't indicate that incentives matter that much. There are times when they matter and times when they don't. It's actually a more complicated issue. Cameron Hogarth have a review of this in the Journal of Risk and Uncertainty in 1999. But my point here is that many judges probably share Justice Rehnquist's view. In fact, we know that a lot of judges share this view. It's a very, very easy mark. Lab studies are very easily criticized, and the few times that judges write about the value or lack of value in lab studies, they almost always talk about the lack of stakes and the artificiality of the experiments. Deliberation. It's a concern. Of course, I know why we don't usually include deliberation in our studies. It's hard. It's hard to get people together to deliberate. It, you know, multiplies by 6 or 8 the number of jurors we might need. But nevertheless, there are a number of very interesting and important hypotheses that come out of deliberation that have remained, I'm going to say, relatively unexplored. I'm not going to say completely unexplored, but relatively unexplored. And for lack of better words, I'll call one the information hypothesis and one the reinforcement hypothesis. The information idea is that we get people together. This is a natural for groups. You get people together, and then we share information. We know different things. And it's a little bit different, I mean, and that may happen in juries. Some people may bring some expertise to trials, and that certainly, you know, that happens in some cases, and it may very well be that deliberation is quite helpful from an information standpoint. It clears up misconceptions. On the other hand, and again, Sherry Diamond pointed this out in a paper in the 1990s, that the deliberation, when jurors are confused, may just reinforce the views, the erroneous views of the majority. So we don't know a lot about this process, but it would seem like it's a pretty important one to get a hold of, and so it would seem that studies that ignore deliberation are really missing something important. As a small aside here, Valerie Hans and David Kay did a study that you know I love, and I've talked about it many times. They published it in JELS and another version of Law and Human Behavior, where they provide some serendipitous support. I know this wasn't the intention of the study at all, but this is the part I always like picking out of their interesting and important study. They find some serendipitous support for what I'm calling the reinforcement hypothesis there. They looked at how jurors respond to mitochondrial DNA evidence. And after seeing a videotaped trial, jurors were asked a series of questions to assess their comprehension of the DNA evidence. And what they found is that deliberation really didn't make them any smarter when it came to the technical issues surrounding the mitochondrial DNA evidence. I think it went from 70 to 73% accuracy on the specific questions that they asked, you know, pre-deliberation, post-deliberation. A very large minority of jurors continued to believe some completely crazy things about DNA evidence even after deliberation. So it didn't seem like the smart people in deliberation were able to clear up the less smart people's views or erroneous beliefs about DNA evidence. For example, 40% of jurors thought that the DNA evidence was, quote, completely irrelevant because it's possible that somebody other than the defendant contributed the hairs that were found in the case. that the hairs weren't uniquely associated, and therefore it's, quote, completely irrelevant. 40% believe that pre-deliberation, 40% believe that post-deliberation. And they also found that there was a reduction in terms of uncertainty, and I think others have found this too, where a number of people were at 50% in the particular case that they used. A number of people said, I don't know, 50-50, guilty, I'm right at 50-50. Following deliberation, very few people were at 50-50. People had moved. And what's interesting, I think, is that the number of people who moved to certainty doubled. So people, if you want to summarize what I've just said very quickly and unfairly, people get more confident and no more smart following deliberation. So that's a little scary. And that's a process, I think, whether it's true or not, it's a process that certainly deserves a lot more attention, I think, than it's getting, and we don't do it because it's hard to have people deliberate. Let me just give a brief example of how I think ecological invalidity can mislead. And, you can probably think of many examples too, but I'll just, throw one out there. Suppose that a researcher wants to know how jurors react to a prosecution expert who's just given, let's say he's given some testimony about some technical matter, let's say it's a forensic science issue, and he's asked on direct exam whether this question here, whether he's ever committed an error. Have you ever committed an error when providing expert testimony, right? And the intent was to get him to say, no, I've never committed an error. I'm perfect. I'm 100% reliable. Well, there's a legitimate question here about how jurors are going to respond to such a claim. Let's say that in our mock study, we have a person saying, no, I've never committed an error. It's impossible for me to make an error. On the one hand, you could imagine jurors would say, wow, that's pretty impressive. This is a great expert. This guy never made an error. He's got a white lab coat on. He looks really smart. I'm going with him, right? So you convict, right? You go along with the prosecution's expert, and you give a lot of weight to that testimony. On the other hand, you could imagine somebody saying, what do you mean never made an error? What kind of scientist is he? He seems arrogant. He seems like a jerk. It's unprofessional. And you downgrade his credibility. It could go either way, so you test it, and you find out in the lab that, I'll make this up as well, you find out that it increases credibility. Increases credibility to say, I've never made an error. And you find this across a variety of different cases and with a variety of different jurors. You use students, you use law students, whatever it is, you find different groups to study, and you find different cases. And so you build up some confidence that the right thing to do, and you advise Christina's attorneys, the right thing to do, attorneys, is to not admit error. Take the stand and say, I've never committed an error. But what did we leave out? We left out all the reality that Christina was telling us about. We left out cross-examination. And there's going to be an exchange. And during that exchange, the expert might say, oh, well, I shouldn't say never. He may pull back a little bit. The expert may pull back. The expert might double down. The lawyer might get the better of the expert. The expert might get the better of the lawyer. Then we go to closing arguments where the expert doesn't get to say anything. And the lawyer gets to characterize that arrogant expert. And so we don't really know how things are going to play out at trial. And even though we've had many experiments that just showed us that when the expert doesn't admit error, it increases his or her credibility, that may be the wrong advice to give Christina's attorneys, because real juries may not find that that the expert's more credible at the end of the day, after all the other stuff that goes on at trial happens. Oh, okay, yeah, this is just, so, those are the points I made. That the ignored aspects may change the result, and the actual result may simply wash out. Whether the expert said yes or no to this question at the end of the day may not even be important given all the other things that are happening at trial. That's something I worry about quite a bit, whether the effects that we find ultimately matter because so much other stuff is going on. If your goal is to describe what really is going on in juries, if your goal is to describe theory, that's another matter. Okay, who is the intended audience? If describing and reforming the jury system are our goals, I would argue that your intended audience, to a large extent, is the policymakers. That we're not just talking to ourselves, we're not even just talking to the broader academic community, which we sometimes tell ourselves we're doing. We're interested in talking to the policymakers, courts and legislators and various administrative bodies and advisory committees for the Federal Rules of Evidence, groups like that. And policymakers are unlikely to be jury researchers. Sometimes they are, but usually they're not. They're unlikely to be psychologists. They're unlikely to be readers of law and human behavior, even casually. And they're less likely to be interested in general theoretical questions. They're going to be more interested in problems that are significant in practice and problems that have easy solutions. Not necessarily easy, I should say, but implementable solutions. And that's what they're looking for by way of research from us. They're looking for us to tell them, how do we fix these problems in the system today? And the solutions need to have those components that I've listed there. You know, they need to be constitutional and have a certain face validity to them and not be too costly, of course. So one of my recommendations would be to follow the advice of Sherry Diamond and Mary Rose and Neil Vidmar and some other people in this room and consider non-experimental approaches if we're interested in influencing policymakers. And of course, it's always great to triangulate. It's always great to use multiple approaches. You know, use the experiments, then follow up with surveys, follow up with interviews with jurors, and if they're all pointing in the same direction, that's likely to be quite persuasive to a policymaker who, you know, otherwise isn't that as influenced as we are by jury simulations. Why? Because they see the same problem the judges see, they see their artificiality, they see there's nothing at stake, and they wonder if they're especially meaningful. Okay. So, in conclusion, if theory matters to you, I would just recommend being cautious when drawing inferences to jury behavior. If jury behavior matters, I'm suggesting that we go to much greater lengths to make our trial simulations realistic, as costly as it may be to us, as much as it may reduce the number of simulations that we're able to do. I think we can say more about what actual juries do when we increase the reality, the veridicality of our studies. And if policy matters, try recommending practical solutions to pressing problems using multiple methods. Thanks.
Good morning. I got involved in jury research for the first time 40 years ago when I was an assistant in Jim Davis's laboratory, and that experience led me, like many of you I suspect, to get turned on to the idea of being able to study juror and jury behavior and the possibility that this kind of work might contribute to some ideal of justice. So over these past 40 years, I've not lost my enthusiasm or my hope, and have spent a fair fraction of my research career delving into the mysteries of the jury. Now I'm very close to retirement, and so I don't have quite the same vested interest in the future as many of the rest of you in this room, but I still do care about what that future looks like. And I have some opinions, they're mostly contrarian ones, I'm afraid, in this room, about how that future should be pursued. But I'm honored and gratified to be here in this conference and to offer a swan song. And you probably all know that see, this thing's working? Yeah, here we go. A swan song is a performance given before death, the retirement, and it harkens back to an old legend that the swan couldn't sing or couldn't make any sound during its life, but just before it died, it would give a beautiful song. I haven't exactly been silent during my entire professional career, so some of the opinions I'll voice here will sound familiar to some of you at least. And I'll have to leave it to you to decide whether this is a beautiful song or just the hissing of some old bird. So let's see. I've organized my suggestions as a bunch of do's and don'ts. And the first one is probably a little bit unusual, coming from somebody who does most of their research on juries and not on individual jurors, and that's, let's not insist on including deliberating juries in all of our research. Whether that's to replicate some phenomenon that's been observed at the individual level, to show that in fact it occurs in a similar way at the group level, or even if we're trying to do initial research where we're not quite sure what goes on. And the reasons for this, I think, are several. The first is that it is more expensive, and I want to talk about that more in just a moment. But another reason I think that this is not as essential, I think, as others might, is that we can, and I think we should much more often, use the extant and very well validated predictive models that we've developed, like the decision scheme model, the Jim Davis's social judgment scheme model, to estimate what these effects would be from observed juror effects. I think we can frequently do a fairly good job of that. Now, of course, we have to issue some caveats about this. One clearly is there are certain phenomena that are really at the jury level and about jury deliberation or about the structure of juries, and clearly we'd have to have juries to examine those, duh. Second is that there's some cases where the models that we have may not fit. So Jay raised the question about whether we can assume that new information or a different form of handling that information occurs at the jury level. And I think most of the models presume not. But if we can make a strong case that there is such a better use of information or debiasing effect, I think most of the research tends to suggest that's not commonplace, but it can happen, and clearly we need to examine those issues. And thirdly, the models we have can't predict in lots of instances, and I think Dennis has pointed out that our models don't make good predictions when we have multiple charges or lesser included offenses or things of this sort. So we may, if we're interested in those questions, have to do some more research and develop better models. Next thing I think we should not do, this is maybe a strong way to put it, is to worship the idol of mundane realism. And this has been a long-running theme in this area. Is there a right way or best way to study these questions? And almost always the prescription is that we ought to do more realistic research. We're doing too much highly artificial research. Why do I think that we're going overboard in this? First of all, I don't think Brian is a straw man, the work he's done. I think that we have some good data that suggests that phenomena are not fundamentally different in more versus less realistic settings. There are some exceptions, and there's some interesting data suggesting you can find instances where that's true. And we do need to develop theory to understand better why and when that is true. But I think, generally speaking, it's not true. And secondly, let's get back to this issue of cost. We usually think about the cost of splitting up our limited research budget. We have NSF representatives here, and I'm sure will tell us that they can't fund all the good ideas that we have. We'll have to try to do the best research we can with the dollars that we have. And that inevitably involves choices. And I think that when we buy greater realism, which generally is more expensive to achieve, we do less research. But I think there's more to it than that, and this is implicit in some of the comments that have been made earlier. My way of thinking about this is from one of my other mentors, Joe McGrath, who in his 72 book on method came up with this circumplex of research methods. And he thought that most of the methods we use could be characterized on this circumplex. And most of the jury research we do is over here in this area. And most of the suggestions we've been hearing and have heard for a lot say we should be moving over towards field studies and field experiments and very much more realistic simulations, or move from these artificial lab experiments to survey research where we can get a better sample than we typically have. McGrath's key point, which bears repeating, is that there is no right method, there is no best method. Each of these methods has its flaws, and that as you move from one to get certain advantages, as you move from these unrealistic things to here, you gain realism and you gain naturalism, but you sacrifice internal validity and opportunity to observe, and these are costs that can bite us. Joe liked to say that we're always on the horns of a dilemma, even a multi-horn dilemma, and when we're trying to choose our methods. And you have no choice which avoids all the horns. You have to choose your poison and make the most of the strengths of the method, but you have to resign yourself to the fact that you're going to be gored on one of these horns, and we may as well get used to the idea. I'll get back to triangulation, which I think is excellent advice too, that Joe gave us. Now, there's a counter argument to this, and we've heard some of these here today and elsewhere, and there's validity to this. One, I think, very strong argument is that the audiences that we'd like to influence will be better convinced by this more realistic research. And there's also, I think, the argument that this realistic research reduces the fears of ecological invalidity, and hence we could apply the research results with somewhat more confidence. If we're actually getting our knowledge from real juries, we can jump into the field and make changes with more confidence. Hence, I think that does this line make it into your talk? At one point, at least the draft I said, is that fewer studies with greater impact would be fine, Jay said. And he had some pictures of some smart people who backed him up on that, including Chief Justice Rehnquist. So who might argue? But I think we can make some arguments against this. I think the first and the most important argument is that realistic methods don't guarantee the validity of the conclusions we come to. And certainly, if the conclusions we're coming to are not valid, then the application of the work, the utility of the work is not going to be what we want. And I'm going to give an example based, I don't know if you guys do this, but my examples always come from what I'm thinking about lately or working on lately. So here goes. And that's what I'm working on now is the effects of pre-deliberation discussion by jurors. There have been a couple of very lovely field studies done on this problem. Val and Paula did one earlier, and Neil and Sherry have done another one that they're continuing to mine for wonderful insights. Looking at this question, and those studies, I think, if this is a fair summary, suggested that there wasn't a very strong effect of letting jurors in civil cases have some discussion during the course of the trial. I think those studies have had a great deal of effect, at least in Michigan, my state. They're talking very seriously. In fact, they're implementing this reform into the procedures of our state. I've got a lab study that I'm working on right now, writing up for a long time, which looks at this question and finds some fairly strong effects of letting jurors have some discussion prior to their final deliberation. Now, my point is not that the field studies were flawed in any way. I think they did what could be done in those studies, but they acknowledged themselves that there's certain things that simply could not be done in those studies. They couldn't manipulate and control the strength of evidence, which we all know is fairly important. They couldn't reduce the variability due to differences between trials. They couldn't make sure that those who were allowed to discuss actually did discuss. So a lot of the groups that had the permission to do so didn't do so, and they were kind of ambiguous about what their behavior reflected. So my point is that let's not assume because it's real that that's the gold standard. And then there's this question of the first point here that the audiences really would insist upon realism, or they're not going to listen to the research we offer them. This may be a cynical view, but in my looking through the reaction of judges and legislators, I find that they're very quick to embrace artificial research when it's consistent with the conclusions that they're trying to come to. And they're also very quick to dismiss artificial research based on its artificiality when it's contrary to the conclusions that they want to come to. I could give some examples. You probably could too. Yes, they do. If they don't care about the outcome of the debate, particularly, they want more realistic research. They prefer it. But they're perfectly willing to dismiss artificial or realistic research if it doesn't give them what they want substantively. That's overstating it a bit. But I think that the idea that we can get their ears and get them to move on controversial issues simply because of the realism of research is an illusion, in my opinion. Now, there are caveats again here. I'm not saying we should shun or disvalue more realistic research. I think it's fabulous when we can get the resources to do it. But I'm saying we should not invariably prefer it or put all our resources in those baskets. And especially regardless of the investigators' resources, their objectives, and the state of knowledge. And this is something that Sherry, I think, wrote about in that very interesting 1999-97 at our ages, you tend to forget when these things were done, which is that it depends on what we know, which kind of methods might make the most sense. The value of very realistic research will increase when there's good reason to believe that there's actually some phenomenon there to be studied. And often it's a fairly efficient way to at least get a first look at this by using fairly artificial and unrealistic, but quite affordable and highly internally valid methodologies. To me, this is very much like addressing the question of whether something is cancer producing. You'll use very artificial methods, use rats and massive doses to see if there might be a problem before you go out and do a full-scale public health study to see if, in fact, artificial sweeteners might be related to cancer rates in humans, for example. I think in much the same way, some of our artificial methods can be excellent first steps and last steps. So, as I've been telling us what we shouldn't be doing, maybe I'll say one or two words about what we should be doing. My suggestion is we focus on research problems that inform legal controversies, that's a good idea, are relevant to proposed or viable innovations, examine implausible assumptions about law and in the law about human behavior, and bear on interesting psychological theory. I'll come in on the side of theory every time. And the first study I did 40 years ago with Jim Davis on jury size and decision rule, I think, was all of these things, and part of the reason we got interested is because it met all of those criteria. And the one that I'm involved in right now, looking at pre-deliberation discussion, I think likewise touches upon all of these. I'm not saying that we've got the perfect means of identifying them, but I think that when you can find the problems that do this, it's more likely to be useful. Now, why these particular things? Well, our training teaches us what the value of good theory is. It helps us organize what we already know. It tells us where to look for new things. It fills in the gaps between what we know. It helps us understand why and when things work as they do. And Kurt Lewin also pointed out that in solving problems, all those virtues are genuine virtues, and there's nothing as practical in solving problems, including in the law and juries, as having an excellent theory. These kind of controversial and relevant to innovation things, clearly you're more likely to get people to fund, act on, and read your work if they care about the problems, duh. So that's not too hard. But Lewin also made the, I think, very important point that doing action research is what he called it. Doing applied research is a terrific way to develop theory and to get insights. And his own work is characterized by that and saying that it's, you don't have to choose between developing theory or doing problems. They're complementary. And last, we're trained to do this. Who but us can not only recognize certain implausibilities, but do the research to demonstrate that those are implausible. My one caveat I'd often hear about what kind of problems we should study is the one that I tell my graduate students all the time. And the very best criterion for choosing an important problem, more important, I think, than all the previous things or any others anyone can give you, is that you find it an interesting problem, and at least you can convince other people that it's interesting. And Shakespeare, at the beginning of The Taming of the Shrew, put this particularly well when he said, no profit grows where there is no pleasure taken. In brief, sir, study what you most affect. And that's sir or madam, I suppose. This won't surprise you. I think we should develop and test better and more formal theory and modeling of juror and jury behavior. We've done quite a bit of this, both for individual jurors. Earlier we heard about how influential the story model has been for thinking about jurors, and I think for juries too. Lots of very useful models. Why should we be doing this? Well, for all the reasons I said earlier about good theory, but especially these mathematical models which give you point predictions, where you can actually say this is where juries should be if this is the way they operate, and then they can be modified and improved through the process of data collection. I think the 40 years of SDS work, since way back there in the 70s, is at least one illustration of the value of formal theory. And I'd like to put in a plug here for Rob McCoon's BOP models, a new psych review paper that just came out, which if I had time I would describe to you, are applying this to the question of whether there's a bias in towards leniency or towards severity in actual juries versus mock juries. If you're curious about it, you buy me a drink, I'll tell you about it at length. And finally, to the degree that, well, I'm a basic researcher, I'll confess it and say that's what it is. I always was glad if there was impact, but fortunately I haven't had to live or die by whether there's impact in my research. But if we are interested in impact, I think the best advice would be, let's do the very best science possible, using all the methodological, theoretical, and statistical tools that we have at our disposal. That certainly means using all the methods in that wheel that we saw of McGrath's, and to make the case by finding convergent evidence across several inherently flawed methods, rather than putting a lot or all of our eggs in one of these baskets. We also, I don't know, at some point we may want to talk about the risk of involving our reputations as objective scientists by getting too deeply involved in the adversarial process. I think that's something that might worth, and I think Christine's talk might be an opening for us to talk a little bit about where we draw those lines. Secondly, rather than, in Jay's words, giving the scientifically naive audiences what they want, I think we need to try to shift what they want from the evidence that feels most familiar to them to the very best scientific evidence we can provide through both general and more focused targeted education efforts. And that's a big picture kind of thing, but there it is. And finally, if we can have any luck at all at seeing who listen and who won't, let's try to at least start and work with those who are receptive, and not be indiscriminate or focus on those who strongly prefer using tradition or intuition over science when it comes to answering and improving the jury system. So that's my long-winded swan song. You can see whether it had some beautiful notes in it or not, and if not, you might agree with the poet Coleridge, who said, "Swans sing before they die, 'twere no bad thing should certain persons die before they sing." Thank you.
Stopped raining. Well, thank you, Margaret, for calling us all together, and in this wonderful surround, and to the National Science Foundation for making it possible as well. We so rarely get a chance to get together all in the same place, just us. And it is a great treat. It's a really wonderful opportunity. I think that what's odd about what I'm going to say doesn't see enormous differences between at least two of the participants in this panel, in that I, in fact, agree with both of them in some ways and disagree in others. So I thought I'd start by talking about race, because that's how we led off. And there, too, I have enormous agreement with some of the points you raised. And I think I would say that one of the reasons that race is probably less paid attention to in your site of the number of articles compared with some of the other topics is because those other topics, in fact, involve system variables more directly than an estimator variable, which for the most part is what race is. And we do have a tendency to want to fix things, right? So the notion is what kinds of changes could be made with expert testimony or instructions, and there's a focus there. So that might explain part of it. I do think that one thing that you mentioned in your presentation, which I thought was really important, is that we don't really understand race as a variable. We don't understand how it influences people in their judgments. And you raised the question about the extent to which class is influenced, and it made me think of of a study that might be done when we treat race as an independent variable. We might go through, and if somebody's done it before and I don't know, you'll tell me. We don't ask people what their picture is of this person, right? We don't ask if the stereotype includes class as a variable. And yet that might tell us a little bit about understanding and unpacking what in fact is driving things. We have some data, and I don't know to what extent multicollinearity explains it, but we find that 4 persons are more likely, like everybody else, are more likely to be selected if they are white versus non-white, right? But that when you put it in the prediction equation and put in professional, managerial, or other occupation and median income, that the race effect disappears. The gender effect has not disappeared. Still, men are more likely to be the 4-person than, but so, you know, so there, I keep on wondering about the role of class in a lot of what we find. Now, I guess a second thing, and this applies to all of the papers that probably all the papers we're talking about, I keep on wondering, and compared to what? And there are some interesting studies done of judicial judges being influenced by race, particularly in employment discrimination cases. And so a good comparison is always to keep in mind, and the jury does what, but compared to judges as well. I am completely sympathetic with the notion of broadening the category, and there are so many reasons why we should not be looking just at black-white. The changes in this country now are gigantic. We all know about them, but they have major implications for the construction of the jury. In one study we did, we found that 1 in 6 jurors were removed for cause, right? That is by the judge. And 1/3 of those who were removed for cause were removed because of language difficulties. These are citizens, right? We also have a 1991 Supreme Court case, Hernandez versus New York, in which it was just fine and peachy to remove jurors on peremptory challenge who were Spanish-speaking because there was going to be an interpreter and a Spanish-speaking witness, and the concern was whether the jurors would willingly follow the directions to take the interpreter's interpretation of the testimony rather than what they could understand from the witness stand. So these are big concerns. We also have in New Mexico, jurors are permitted to sit if they don't speak English. It's in the New Mexico state constitution, and the state has to supply reasonably an interpreter for them, not just Spanish speaking, but Navajo. The jury pool is changing in significant ways that reflect race, and we need to understand a lot more about it, cultural backgrounds being different and all of that. So that would be good. I guess what I wonder is how much stereotyping can be unpacked by more information. So that one of the problems in a criminal case is that the defendant frequently won't take the stand because the defendant has a record. But I would love to see some research on what happens if, in fact, the defendant does take the stand. And we know from Valerie and Ted's work about taking the stand being an important variable, and the old work of Whistler and Sachs. But the question is, what will that do if you get to know the person, or you get a more extended voir dire and you get to know more about them? So we don't know how race plays out in that area as well. I think that keeping in mind the system versus estimator problem is important, and maybe there's still more work to be done with respect to Batson, where that is in fact a potential system variable in terms of manipulating that. So, but the topic is right, the coverage is beautiful, and I hope we will see the chapter soon. So, on Norb and Jay, they seem to be at complete odds with one another, right? Except that they each add caveats, right? So when you put them together, and I had the advantage of having, PowerPoints beforehand, when you put them together, you get to see, the caveats make it seem like they're really on the same page, to some degree. Maybe you have triangulation, you go in stages, and you cited 15 years ago, but later on I wrote about first stage and second stage research. So actually, it's, I guess I'm an elephant, right? Different parts say different things. So so I guess I don't see quite as much difference between you, except perhaps in one important area. And I think this is where you and I, Norb, probably disagree. And maybe that's because I've been living with deliberations lately. I think deliberations are actually more important. I think, dearly as I love Calvin and Zeisel, that they may have done us a disservice by making it just like a photographic development that produces the verdict from the initial votes. The reason I say that is a couple reasons. Part of it comes from a paper that you sent us, which is not in your PowerPoints, where you talk about the power of Jim Davis's decision scheme theory. And I am troubled by reading too much into the power of that, and I'll say why. And my problem is, and I don't have a good solution for it, my problem is the problem of hung juries. And as you all know, hung juries are very frequent in almost all simulation research. I wrote down some numbers from Dennis's study, and when the initial vote was 10-2, if I got this right, you have 35% hanging across a bunch of studies. 9-3, 59%. Now, to me, that means that the robustness of the deliberations is a problem for drawing from those data a really strong conclusion about how we move from individual preferences to verdict outcomes. And the other piece of that comes from and those are situations in which there's a pre-deliberation vote, and in general, as you say, the deliberation participants on their pre-deliberation vote are put in a forced choice position. So they can't say undecided, right? Which gets to the second part, which is jurors, contrary, as you all know, to some popular images, don't tend to take an immediate first vote. The majority of them don't take an immediate first vote. In Hasty's study, 28% of them took a first vote in the first 10 minutes. In the post-trial real jury retrospective reports, the range goes from 3 to 31%. In our Arizona real jury deliberations study, 20% took a vote within the first 10 minutes. And what we can see from our deliberations is that people get derailed. They start talking about the evidence and questions that arise. And I think that comes about because, and maybe in some of the basic studies we do, people do in criminal cases come in with strong beliefs. But in lots of juries, the jurors are simply not there yet when they come into the deliberation room. And that means that deliberations has plenty of room for an opportunity to influence outcomes. And we don't have good measures that would allow us to tell us whether the models that we have really explain what is going on. I wish we did. So that is a problem. And I guess the other piece of that is I have seen, we have a paper on jurors and the law coming out in the Northwestern Law Review in the next month or two. And we can see what goes on during deliberations and talk about the law. Well, you know the literature. It all shows that the jurors are hopeless, that they can't get the law right, that they do badly on comprehension tests. And what we did was we counted every time they got something wrong, and 80% of the time their comments are consistent with the law, and half of their errors tend to be corrected during deliberations. Now those are in Arizona juries where the jurors have, each one has a copy of the instructions and they consult them during the deliberations, and maybe Arizona is different in some way, but it suggests that some of our individual juror verdict information may be not have all the elements that Jay was suggesting might enrich our understanding of it. I would love to see more elaborate simulations like Reed did these many years ago, where jurors are really committed for a whole day or 2 days, and they know that as soon as they reach a verdict, they're not going to immediately go home. Maybe that would get the hung jury rate generally down, and we would have some better models. So I'm not of the minimalist persuasion as an ultimate goal. As a first stage, absolutely yes, and I'm hugely in favor of those preliminary things, but I don't think one can stop there. So finally, Christina, it's so refreshing to hear about different audiences, right? You know, we always think that we are writing either for ourselves or for the courts, and there is that other audience out there, and it's always a problem in a way because academics don't tend to pay attention to that audience, and maybe that's appropriate, you know. So maybe we shouldn't be doing that. We should focus on what we do. I'll just tell a story. There's always this tension when you propose a jury reform based on anything, right? You know, you say, well, should jurors be allowed to submit questions during trial, right? Well, the plaintiffs want to know, will it help them? The defense wants to know, will it help them? You know, so I just pay attention to the court. I can't be involved with that. But it's very much on my mind because we had an interviewee who is an attorney who is going to be participating in a conference we're holding for practitioners mostly, and he said, oh, back-to-back experts. Now that's interesting. Well, I think it would probably help the plaintiff, because usually we get the last word, and he just played this out in the newspaper about his feelings about how it would work out, and I realized there is just no way. I mean, every time an attorney has something to say about what is going to happen with respect to a jury reform, you have to pay attention to the fact that if it helps one side or the other in an obvious way, it's going to have strong opposition. So you've got a problem. Finally, because I think I'm taking too much time away from the instruction. I think, Christina, you have it exactly right in terms of what the jurors are doing that we see. Neil Feigenson said it, you know, the economists keep on talking about optimal behavior, right? Optimal deterrence, optimal behavior in negligence cases. And the jury's thinking about these two parties that are in front of them for the most part, unless punitive damages are involved, and getting the balance right, you know, trying to figure out how you avoid injustice being done with the two parties who are involved. Topics that we haven't talked about as much as I would like to see. The jury is changing in ways that are not just about ethnicity or race, but you may recall that in the Apple versus Samsung jury, the foreperson of that jury was an electrical engineer with a patent. And he was not the only engineer on that jury. There were two other engineers. There is an expertise, now that we have eliminated most of the occupational exemptions, that is cropping up across the board. And we need to understand how those jurors behave during deliberations and what contributions they make, what problems arise because of their particular expertise. We talked about personal experience. Yes, jurors, Mary could tell you many, many stories about personal experience. The jurors pool that, and yes, jurors are different in their personal experience background than the average college student, and that makes a difference in how they talk and what they draw on. So we need to know more about that. And finally, the internet, right? The internet has intruded in all kinds of ways, both in terms of what jurors expect to hear in the courtroom and what they are worried about outside in the world while they're sitting there and can't turn on their BlackBerry or Apple 5. Courts are struggling. So if you're interested in policy impact, that's definitely a place to go in terms of studying. Thanks.
The danger of putting yourself at the end is you might not have any time to talk. So I have been frantically cutting my comments. There goes page 1. And I also realize I'm keeping you from not only discussion but lunch, and so I'm going to try and be brief in my remarks. And Sherry did such a great job of touching on so many aspects of the other talks that I was going to mention that I'm going to leave those out and try and hit the 2 key points that I wanted to make. First, I worry that we ignore all sorts of types of validity when we talk about our research, that somehow ecological validity has become the holy grail. And I think it's a big mistake to make that our real focus. And sometimes I worry about the terminology that people use, and I don't think it actually reflects the terminology that Cook and Campbell gave us. And so just real briefly, to me, ecological validity means whether a study mimics real-world conditions. I am very concerned that people confuse that with external validity, which is an issue of whether findings can be replicated in other settings, other populations, other times. And when as an editor, as a reviewer, and as an author, when you see, your studies won't generalize because of some feature of the study, I'm like, that's not the question. The only way you can know that is if you start doing conceptual replications. And so this kind of knee-jerk reaction to, it doesn't look like what I think the real world looks like, and therefore it's not externally valid, it won't generalize, I think is a problem. And probably it's mostly a big problem for me because I'm not sure what we're generalizing. If in many of these cases where we go to extremes to focus on ecological validity, we lose features of internal validity. I'll argue that what Jay was talking about earlier was not ecological invalidity, it was bad construct validity, that you had a bad manipulation, and that we don't ever hear anybody in our field talking about construct validity, really. I think with the exception of Rich Weiner a little bit. There's really not much thought to that. And if we don't have good construct validity, we can't have good internal validity. We can't know what causes what. If we don't know what causes what, I'm not sure what it is we're concerned about contributing to our legal knowledge, because I'm not sure we know. And so that's a very condensed version of what I was going to say on that. Really what I've been thinking about while organizing this conference is thinking about what questions we should be asking, what's important, what's interesting. We have a saying in my lab that just because you can manipulate a variable doesn't mean you should. That lots of variables are really not interesting to manipulate. And I've been trying to think about how to communicate to my students and to others, because I have to do this as an editor quite a bit. I've got reviewers coming back saying this just isn't interesting. And then the author's like, well why? And then trying to articulate to them, and I'm usually agreeing with the reviewers that it's not. And I've been trying to really articulate what is it about something that makes a problem interesting. And so I'm going to focus a little bit I'm going to focus my comments on research that has an applied focus. By doing so, I don't mean to dismiss work on basic psychological theory. I happen to like it. I'd like to see more of it. At LHB, we just don't get that much of it. But a highly theorized work that elucidates legal processes as well as contributes to basic psychological theory would be very welcome there, and I would appreciate seeing it. But a lot of what I see is not that. And in thinking about advice I would want to give, I think back to a conversation I had with a student of Gary Wells, who came to me at an APLS and said, I'm thinking of doing this study. And she says, but I want to know, what do you think makes a question on jury research interesting? And I thought for a second, I was like, well, I just know if it's interesting or not. And then I realized that was admittedly a really condescending and unhelpful answer to give to this student, but really wasn't able to articulate well. I knew an interesting study when I saw it, but I didn't know how to tell her it was in what made it interesting. And perhaps because it was Gary Wells' student that I was talking to, I eventually turned to thinking about estimator versus system variables as a framework that we might use. And I think this is a really useful framework. I think it encapsulates a lot of the points that were made by our earlier speakers. Some people in the room are not going to be familiar with estimator and system variables. We've been throwing the terms around, so let me just tell you what I mean by that. In 1978, Gary Wells argued that research on eyewitness identification typically examined one of two classes of variables. That estimator variables were characteristics of a witness or a witnessed event that measured or estimated, but could not be controlled by actors in the criminal justice system. So the witness crime could be more or less stress-inducing. The perpetrator may wear a hoodie or might not. The witness might be the same or a different race as the perpetrator. These variables, stress, perpetrator disguise, cross-racial identification, influence the accuracy of eyewitness identifications. But none of these variables can be changed. They are what they are. And so they can help you post-dict the accuracy of an eyewitness, but they can't help you improve the accuracy of identifications, which is really a goal of much of the research. So he argued that instead system variables, variables that were under the control of the legal system, like how a lineup was administered to a witness, might be a more fruitful avenue of research, and that you could use this work to encourage change in the legal system and promote justice. And I've been thinking about whether a similar framework might be helpful for jury researchers. So if you think about it in terms of jury research, estimator variables are those variables that influence trial outcomes, certainly, like verdicts and awards, but they're not under the control of the judicial system. Examples could include race, age, defendant attractiveness, litigant attractiveness. This research can only be used to predict trial outcomes, but not improve the quality of the decisions that are rendered by juries. It's not going to improve the quality of the justice we dispense. So I'm not saying these variables are not useful to study. It's not that they don't provide important information in some context in the legal system. They could be used to help a defendant decide whether to accept a plea bargain. If this variable is present, I'm more likely to get convicted, and so therefore I might want to accept a plea. In a civil case, it could be useful in determining whether you wanted to accept a settlement offer, but they're not going to improve anything. They're not going to make jurors better decision makers. They're not going to make the system more fair. In contrast, system variables are characteristics of the trial that are under control of the litigants or the court. They could include instructions to the jury, whether trials are bifurcated, and how voir dire is conducted. System variable research might address practical problems, such as how to increase juror comprehension of judicial instructions, how jury size affects the decisions that juries make, and the effectiveness of safeguards intended to improve jurors' evaluations of expert evidence. Because of its focus on characteristics of the legal system that can be changed, system variable research is more likely to produce findings that improve the quality of decisions that jurors render, influence public policy, and increase the justice that defendants and victims receive. So how does this proposed framework fit with the comments of our speakers today? It's consistent with NORB's call to study the behavioral implications of jury policies and procedures suggested by case law. Jay recommends studying the environment within which decisions are made, as well as suggestions for jury reform, and that encapsulates system variables. Jen mentioned system variables in her talk, talking about situational moderators of racial bias. And Christina, certainly, all of her whole talk was talking about the importance of studying things that are under the control of litigators. I guess what I'm going to argue is that system variables encompass all that and more. And including variables that are under the control of the court and potentially under the control of victims and witnesses. So although I'm certain that there are other variables and questions that are important to study that may not fall under this rubric of system variables, I do believe that this system estimator variable distinction that Gary created for eyewitness researchers could prove a useful guide to jury researchers for conceptualizing important research questions. And certainly Gary's framework, if we want to look at it as a model, redirected research efforts in the eyewitness arena in a way that produced a large body of research that had a profound effect in the legal system. I think if we're to look at any body of research that has had an impact on the legal system, we can look to that one and for certain say that it had an effect. Similarly, a focus on system variables in our research, such as remedies for the effects of death qualification, pretrial publicity or adversarial allegiance in expert testimony, procedural reforms such as those proposed in Arizona, or safeguards against the influence of junk science on jury's decisions could provide data that could inform public policy. Jury researchers would be lucky to make the inroads that eyewitness researchers have made when it comes to influencing policy. Perhaps a shared focus on system variable research could help us make those inroads a reality. Okay, and that's what and we got 7 minutes, is that for discussion? So I'll open up the floor. We can maybe run a little bit over. I know they're setting up lunch outside, but if anybody wanted to start in on the conversation, ask questions, make comments. Yeah.
Okay, very exciting first session. I guess I have a friendly amendment, your list of the 3 goals of the work that we should be doing: develop theory, describe how juries decide, and evaluate and reform the jury process. I think I'd add, I don't think it's in these 3 things, but I would add understanding what difference it makes to have a jury. And I think that's a really critical question for all of us at this time when there is a very substantial decline in jury trials, as there is with all trials. And also for the expansion of new lay participation systems in other countries, an issue we'll come to tomorrow morning when we do that session on global juries. So, friendly amendment.
I'm going to later also draw on the eyewitness literature for some of my comments, but I do want us to remember in doing so that they are in a fundamentally different position because the jury is constitutionally protected in a way and police are under different levels of levers of control, and courts have more remedies for saying, I think, you must do something this way or that. And being able to say, you know, the way you're doing your system doesn't meet our the rules we want. And they can certainly do that in some instances with the jury, but you have people who are very loath to interfere with the jury. And I just want us to keep that in mind, even though I'm going to argue that we need to match their vigor of interest.
I just want to call people's attention to the fact that some of you may not be aware that North Carolina passed a Racial Justice Act for death penalty cases. There are currently 100 cases under appeal, and there is wonderful work by Grosso and O'Brien that has been before the courts in Cumberland County, and among other things, in terms of selecting capital punishment jurors in Cumberland County, for example, everything else equal, blacks are kicked off at a rate at 3 times that of whites. And I think that article by Grosso and O'Brien is coming out in the, or is already out in Iowa Law Review, and I encourage people to look at it. I wrote, this is a nickel-dime article from my standpoint, but I actually wrote a little article that's coming out in the Iowa Law Review as well, talking about why it's important. And it's very superficial, it's very short, but at least trying to draw the attention of decision makers to that. But I think Grosso and O'Brien's work, which I've gone through now, is just wonderful, and it raises very serious questions. I've recently been talking to prosecutors, and of course North Carolina prosecutors have their backs up about the whole racial issue and how it's been politicized. One of the things I was a little bit successful so far with is trying to say, it's not saying that you are racially biased, but rather it's more the implicit bias that affects the decisions and so forth. But anyway, that's one of the sensitivities when you start trying to change courts and so forth in these instances.
I had a collection of thoughts going through my head with the different talks, and I was trying to get them written out before I raised my hand, so I haven't thought through everything. But I really enjoyed them, so thank you to all the speakers. Just a couple kind of bullet thoughts. I really like Jay's framework about the 3 different things that we ought to be studying, and I would heartily agree with that. I was a little curious, maybe when I get done talking we can get your thought on this, but why for the first goal with regard to theory, at least on the slide it said less, and I wasn't sure if you meant just research that tests specific theories or just sort of in an opportunity cost way of thinking. If we have to choose, relatively speaking, this would be less important than the other ones. But I really liked that framework, and it is very consistent with the way I think about it. Let's see here. I think with regard to the issues of methodology, my thought is that I would certainly agree with Margaret that construct validity is pretty important and that maybe we don't focus enough on that. And concerns about ecological validity and external validity certainly are important, but aren't the only things that we ought to be focusing on. And in particular, when I review studies that measure individual difference variables related to jurors or sometimes defendants, I get concerned that maybe we're not focusing in well enough on what the most important ones are. And I think their construct validity is pretty important as well. I think my reaction to concerns about external validity and ecological validity and those sorts of things is best answered by something I think Norb was getting at. You can tell me if I'm wrong here. That I really like the idea of convergence or triangulation. I think that is the way to look past these concerns and as a field to get over them. I don't trust the results of any one particular study, my own work most particularly, but if we see it happening enough times from case studies and archival research and field experiments, then I have more confidence in that. So I think that is the whole foundation of psychometric theory. If we get enough observations, the error is going to sort of cancel out and hopefully the real phenomena will emerge. I think that's the best strategy. Of course, it's a long-term one. It means that we're not going to get an answer for some of these issues until we get down the road a little bit. And then I had one other comment, I think. Oh, the last one was for Christina, and we were talking a little bit yesterday, and the issue of doing research that would be of interest to practitioners, I have very ambivalent feelings about that. I kind of hope that our work in general, and my work in particular, is sort of pro-justice as opposed to pro-plaintiff or pro-prosecution or pro-defense. And I guess I found myself wondering, well, maybe you would not be, you were Dennis Stole, her colleague is a good friend of mine, and I've talked with him about this too. He's at ThemeVision as well, and I just wonder whether that concern doesn't sit real well with me, just in the sense that I hope that what we're doing is making for more fair and more accurate outcomes, not necessarily one side winning or the other. So if you told me that you were sure that you were on the right side, I'd say, here's all the research that I've got, go win that case. And otherwise, maybe I would not want to give it to you. But so I have mixed feelings about that. But that's not to say that I don't think that there's good research that we can do that can be used by litigators and trial consultants that can help to achieve or increase the probability of getting more accurate outcomes. So ultimately, I hope that's what our work as a field does. So.
I have a question for our NSF person in the back, because I will say that I was doing, finally got it funded, a grant proposal on jury selection, but I had a lot of complaints from the reviewers that why should NSF be funding anything that helped litigators? So I like Christina's idea, but if we're not allowed to help them and get funded, that might be a fruitful area for some people to follow.
Okay, so
Yeah, sure.
So as I'm sure everyone in this room knows, with the possible exception of the graduate students, and you should learn quickly, there are two review criteria for National Science Foundation. So really we do emphasize basic research, and we do emphasize intellectual merit, which means somehow you need to be moving your field forward and you need to persuade a bunch of your colleagues that you're moving your field forward. The other part of that is the other review criterion is broader impacts, and there are many things that count toward that. And it means usefulness to communities. And so if you've got a community and that in some way includes litigators that will find this useful, that's okay. But that's part of broader impacts. That's not intellectual merit, right? And so I know that's an answer everyone in the room knows, and I apologize for that. The other thing to know is that, again, you all know this, you review each other's work. You think about what it is that you would like to say, and we've seen some disagreement in this room, and so you're going to get some disagreement in reviews, and after that, program officers make our best assessment about how much we care about it. If research is, and of course we don't have the particular proposal in front of us, and we shouldn't, if research is wholly aimed in terms of this is going to advance the plaintiff's bar in this way, it's just going to get thrown out. That's not what's going to happen. It's not going to review well. But that is part of broader impacts isn't an issue. Does that answer you well enough?
And I would say that this proposal I was talking about was very much more broadly
Yeah.
but they kept it
Right.
But this could be used by litigators, and that would not be good. So I'm just saying that
No, that's,
if
yeah.
somebody picked out this as a potential broader impact,
Yeah.
among others, and,
Right.
and obviously you think of some community you didn't want to help, you didn't want that.
And some reviewers might well raise that as an issue, but as you know, not all reviewers will, and program officers don't. We decide how we weigh the comments that come up in reviews. Okay, so some things we absolutely discount as concerns.
I just wanted to follow up on Dennis's comment about different types of validity. I think it's a distinction that is incredibly important, and too often we overlook it. But it's almost impossible to increase one type of validity without decreasing other types of validity. Margaret mentioned Cook and Campbell's taxonomy for different types of validity. Many of you are probably familiar with last year's special issue of Behavioral Sciences in the Law on some of these concerns, edited by Rich Weiner, Dan Kraus, and Joel Lieberman. I don't want to say too much about it because maybe Dan's planning on talking about it later. But I would suggest taking a look at it, especially the introduction to the special issue, which applies Cook and Campbell's taxonomy of different types of validity to jury simulation research. And it's nicely written and very informative article. That's my plug for you, Dan.
I just want to respond briefly to Dennis. The answer is yes. The question was, is it just for opportunity cost reasons that I recommended less theory? Yeah, that's the yes, yeah. So it's, and I also just want to say that you won't find a more eloquent spokesperson for the views of Norbert Kerr than Norbert Kerr. He was incredible. He was incredible today, but you should read his work with Scott Tyndale, read his work with Bray. I mean, anything by Norbert Kerr is worth reading. The problem, though, with Norbert Kerr is that because his views are so persuasive, because he articulates the view as well as it could be done, the rest of us are going to be inclined to use those views as a crutch for not doing the kinds of things that I recommend. That is, we're going to say, it's very easy to say to ourselves, well, I'm just interested in theory, and well, we don't need to worship at the idol of the realism gods. But if we are interested in describing what juries do, I just think sometimes we have to hunker down and do that which is most uncomfortable, and that is introduce some of those elements that are going to be highly costly to us in every way. So I just think we should all take a clear look at our own research programs and say, are we really just interested in the abstract theoretical issues, the goal 1 issues, or are we also interested in goals 2 and 3? To the extent we are, I think we need to bend a little bit away from the Norbert Kerr suggestions.
I agree with what Jay just said, that it all depends on your goals, and you have to think early on, is my goal to contribute to theory? Is my goal to describe jury research? And I think one of Dennis Devine's comments about not necessarily wanting to help one side or the other unless you know who's right is that is the essence of the jury system, that we don't know who's right. And that it's true that we don't want jurors making inaccurate or what I'll call inappropriately biased decisions, because bias is what attorneys are trying to do through the trial process. I'm trying to persuade you. I'm trying to bias you in legitimate ways with the evidence and the arguments that I present. And that even if jurors weren't making any errors, I don't think we know what the accurate answer is. We know when they make errors, but that's the whole thing, is that there isn't necessarily a right answer. It's the just answer for the verdict and given our system. And so that was the point of my comments, is that I think there is importance in describing what jurors do, and attorneys are a big part of what jurors receive in order to accomplish their task.
So I just wanted to say, I think that one of the distinctions that seems to be being made isn't necessarily, because I don't think that you necessarily can't contribute or can't describe accurately what a jury does or increase your realism without theory. I think that underlying theory or developing those theoretical paradigms really can help us, help litigators, or help or describe the actual jury process. And I think, Christina, in your talk, you brought up the story model and how that's very appealing for attorneys, right? Because I mean, the takeaway that they get is to tell a story. But then you brought up some points that we should look more at the characteristics of the story that make the story more, cover more of the evidence, make it more coherent, make it more unique, that in essence are going to make it more likely that the jurors choose that as a best story. And so I think that by developing those theories, both at the juror level and the jury level, that we can have our cake and eat it too a little bit more. So both be able to predict and describe what happens in the jury setting, but also develop those underlying theoretical paradigms that are going to help us understand jury decision making at the more basic level as well.
That's putting a bit of a pressure on me, Margaret. I want to echo Dennis's point about the ambivalence towards sort of providing the fodder for litigators. And I sort of share the concern of, what are we after? And Dennis said, I think, justice, and I would echo that and say maybe just the accuracy of the process. And Christina, your response was, well, given the system, this might actually help. I think one of the questions that we might want to be asking into the future, Margaret, is should we question the system? Do we buy into the adversarial system as the right system to explore these issues? Personally, I don't. And I think that there's a lot of good research to be done in this regard. And until that point, I'm with Dennis. I would prefer that our findings wouldn't help one side beat up on the other. I don't find solace in the fact that, oh yeah, the jury will figure it out and we're providing them with the best of, information and tools and such. No, I think lawyers, that's not exactly what lawyers are trying to do. And as you mentioned, they try to win cases. And if it's by distorting or further biasing, then that's okay in the adversarial system. But to me, that's more of a reason to study and question the adversarial system than to, help one side, beat up on the other.